From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Damianakis, Caulfield, Averill, Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is 5 o'clock on Tuesday, and that means you are here live on FLALAW on the radio. My name is Matthew Noyes, and I'm one of the attorneys at the law firm of Damianakis, Caulfield, Averill, and Noyes, the proud presenters of FLALAW on the radio. Our firm is the oldest personal injury law firm in Tampa Bay. We have been serving people injured in car accidents, work injuries, slip and falls, even Social Security disability matters for 70 years. Guy Damianakis started our firm in 1955, downtown Clearwater, and we have been here in Clearwater ever since. So as a thank you to our community, we proudly present FLALAW, which is really a live call-in show for you to ask any legal questions that you have. I am here to answer questions regarding personal injury matters or workers' compensation or even Social Security disability matters. But I also have a special guest here to answer other questions that we'll get into in just a minute. 3 ways to get to us if you have a question. One is to give us a call. 727-441-3000 is the number to call. And we'll get your call on the air, and we'll be happy to tackle your question, comments, or concern. If it's just really a comment, we're happy to take those as well as questions. The second way to get to us is we are Facebook Live right now. Our firm Facebook page is Damianakis, Caulfield, Averill, and Noyes Injury Lawyers. And my guest and I are right here. You can look at us in the studio. You can type in your question right there, and we'll be happy to tackle that question for you as well. So that's the second way, on our Facebook Live. And the third way is through our YouTube channel, Damianakis, Caulfield, Averill, and Noyes Injury Lawyers YouTube channel as well. Ed's on the other side of the glass. He's checking that out. And if you type in a question on our YouTube channel, we'll be able to tackle those questions as well. So 3 ways: telephone, Facebook Live, or YouTube. We're here for you for the next hour live, so please feel free to contact us. But without further ado, let me introduce my friend and my special guest, Tony Damianakis. Tony, thank you for joining us again today on FLALAW on the radio.
It's great to be here, Matthew. Thanks.
You told me just a little bit ago that you just came back from a vacation, so I really appreciate you coming back. I know the days after a vacation can be a little crazy, so I appreciate you taking some time to help our listeners with the areas of law that you specialize in.
It's an honor to be here. Thanks.
Why don't you tell our listeners a little bit about yourself? Where did you go to school? What brought you to Tampa Bay and such like that?
So I was born and raised in New York.
I never would have guessed.
I attended all college, did a master's degree, and then went to law school at the City University of New York. Started working as a lawyer for 4 years. And in 1997, I decided to move to Florida. My dad was sick and retired here on disability.
Okay.
So I made the move to start fresh and came down to be closer to him. And it worked out great. I love the Tampa Bay area. I've been here since 1997.
Great.
I met my wife in 2002. We have 4 children. Started my own practice in 2004.
Okay.
In 2006, I merged with Peacock and Gaffney, the late Ray Peacock and Pat Gaffney.
Staple in the Clearwater Bar Association for so long.
Long time Clearwater business, real estate, litigation lawyer. And I pretty much took up the mantle running with that side of things: real estate, probate, estate planning, litigation, and business matters. Patrick Gaffney, my partner, does family law, and we have a great relationship since 2008. We started our own firm after Ray died in 2007.
Yeah, and he's been a guest on our show from time to time as well, too.
Yeah.
So I got 2 very smart people from the same law firm coming as guests on our show.
So I'm doing this now 32 years.
Wow. Good. Now, I became a personal injury attorney because I got in a car accident when I was 16 years old. What made you want to become an attorney?
Great question. My career goal and reason I went to law school was to be a politician.
Oh,
Actually.
okay. I didn't know that.
And when I thought I could make a difference. As a young student, I started realizing that the decisions that the government were making, had impact on our lives. We paid a lot of taxes, and they were using the money in setting priorities for society, and I wasn't really
in line with those.
I was
Yeah.
pretty much concerned the way things went, and as you
Yeah.
might imagine, we're still in the same boat. So I went, got out of law school, ran for office, school board up in New York, got elected,
Oh.
served 3 years. But then when I came to Florida, I had to start fresh. So not knowing anyone, that political career had to be shelved. Getting married, having young children, it was further shelved, and it's been
Yeah.
shelved ever since, building a
Okay.
practice. But the decisions that, I still watch from afar.
Right.
I'm an independent.
Yeah.
I'm not bound to either party. I'm not happy with either party,
Yeah.
unfortunately.
Well, I mean, you thought about being a politician to help people, and gosh, for these 32 years, you've been helping a lot more
Yeah.
people probably in your law practice
So
than if you were a politician.
it's a great point. The transition to helping and making a difference comes through the practice.
Perfect.
So even though we make a living doing it, we also help people. They come to our office with their problems, and we try to find an economical solution that makes sense for them and a good outcome.
Right. And
Yeah.
I mean, it's even though it's a different area of law than we do, it's the same situation. They're lost. They're thrown into a legal situation that they don't know anything about, and they're turning to us to try to get some guidance in there.
Yeah, in your field in particular, they come to you not only lost or needing answers, but they come to you with a physical disability
Right.
or an injury. That's really hard. And I know from referrals to your firm that you guys really do a nice, compassionate job.
Thank you.
You're very honest with people. And that's why I know when I refer a case to you guys, which I always refer my personal injury matters to you, that they will get a straight answer. So if they don't have a case, you'll tell them. If they have a case, I know you'll fight hard for them. So that's something I appreciate about you in particular and
Thank
your
you.
firm.
Yeah, thank
Yeah.
you. I think it is important. We are advocates for our clients, and so it's important that we fight for them the best that we can, fight the fights that need to be fought, and resolve the issues that need to be resolved. And I think whether it is personal injury or whether it is estate planning or probate or even business law, real estate, that's the same motto that I think people have to have. You can be the bulldog attorney, but if it's not getting results, you're not doing your client the best effort. And that's what I really appreciate about you and Patrick, that you guys put the client first. You put the ego aside and you put the client first, and you try to get resolution for the client. And so that's wonderful. So when you're not here on the radio, and when you're not in your law office or in the courtroom, what do you do for fun?
The primary occupation is raising 4 children.
Yes, I was
as
going to say, I do that answer with 4 children, but and they're a lot of fun.
There are a lot of fun. And
Your son and my son played baseball against each other in Little League, but
Yeah.
it was always fun to see them play.
So that's a great blessing. I'm very involved with my church.
Right.
I'm also studying to be a deacon in my
Oh, are
church.
you?
Yes, I just
Wonderful.
completed a 3-year course at a Holy Cross Seminary,
Oh, good.
and now we're waiting on.
You don't have
People-
enough on your plate. You got
No.
to do that too.
So I like giving back in that fashion.
Yeah,
now.
that's wonderful.
Visiting hospitals and nursing homes, and see what we can do to be present for people.
Oh, that's wonderful.
Yeah, that as I get older, and I hope to spend more and more time doing that.
Yeah, no, that's great. Well, let's delve into your areas of law. You're here today, here on FLA Law on the radio. What areas of law do our clients our listeners may have questions for? What areas of law can you address?
So we've been working in the areas of real estate, business, litigation, estate planning, and probate.
Okay,
Pretty much. And if I don't,
that's a wide variety.
If I don't know what to do, I can tell you who does. So,
Yeah. Well, let's first start with real estate law then. Okay. what is the most frequently asked question that a client comes into you on a real estate practice?
The most frequent question I would say is, what's it going to cost me to
Okay.
either buy or sell a property? So when you're selling a property, the costs are pretty standard. In Pinellas County, the seller will pay title insurance. Title insurance is determined by the price of the house. It's a statutory fee. So no matter who you use for your closing, it should be the same amount for the title insurance.
Okay.
And that's again based on the price of the home. Then comes the variations. There'll be settlement fees assessed to both the seller and the buyer. You want to ask whoever by the way, since the seller pays for title insurance, the seller picks the title agent.
Okay.
So don't let a lot of times realtors have firms title companies that they work with. They automatically assume that you'll be using theirs. You as a seller have the right to shop, and you have the right to pick who you will use as the title closer. And one area to ask about is, what's the settlement fee? If there's an attorney involved at the title company, what's the attorney fee? You don't want to be paying an attorney fee as a seller if you can avoid it.
Sure.
You just want to pick the title company, pay the settlement fee, and that'll be it. There's also fees, doc stamps to the state of Florida, documentary state tax it's called, that a seller will pay. And then again, based upon the sale of the home. That's about it. As a seller, you'll pay off a mortgage if you have one, but that's between you and your bank. The closing agent will get a payoff statement, and that'll be paid at the closing statement. You'll pay some of the taxes. Real estate taxes are run from January 1st to December 31st. So let's say you close June 1. You would be responsible to give the buyer a credit for January to June
Okay.
for the taxes that you would have occupied the property for.
Okay.
Other than proration on taxes, paying off your debt to your bank, doc stamps on the deed, settlement fee, you should not have too many other things. Sometimes there are adjustments and bargains made with the buyer. You might give them a credit for certain repairs that they objected to, and that can be on your closing statement.
Should a seller have an attorney? Watch out for them.
I always recommend buying or selling real estate to have a lawyer. It's relatively inexpensive.
But the benefits of having the attorney looking over the documents, it can be a nightmare if there's a mistake.
If there's a mistake, or if someone slips something that you should not have signed in front of you, thinking that it's standard practice. So always have an attorney at a real estate closing, buyer or seller. Buyer side's a little more complicated, especially if they have a lender. They'll have a whole stack of lender documents that they'll need to sign. There'll be costs associated with that loan on their closing statement. And most importantly, the buyer wants to know that they have clean title.
I was going to ask you about that.
So you'll need to have a lawyer look at the title report, make sure it's from a reputable title company, make sure the proper liens and encumbrances have been cleared or are non-eventful. And you want to get a title insurance policy that if there's a problem that comes out of nowhere, you'll be made whole. Very important.
Does the seller or the buyer buy the title insurance?
You get the insurance as a buyer, seller will pay for it.
Okay. So it's so important to have that.
Very important.
What happens if there's a bad title or a dirty title? I forget what they call that.
If it's a defect, an encumbrance on the title or a defect in title, and it's through no fault of yours, in other words, you had no notice and no reason to know, then the insurance company, you'll have a title insurance policy, should step up and either fix the problem or give you back your money.
Okay.
Very important.
You could lose the property.
Yeah, if they pay you the property, they'll probably take it to mitigate their damages.
Okay. That's very important to understand. That's why title insurance is so important. I would say just like any insurance is so important.
Yeah.
What's the biggest legal mistake buyers or even sellers make when, in Florida at least, when there's real estate deals? What do you see? I mean, you come to avoid those mistakes, but I suspect you have people come in and say, "Oh, I tried to do this transaction and X happened. Fix it for me, please, Tony."
So lots of mistakes happen. Number one, don't get in title. You fail to get title insurance. Number two, you give a deed without getting paid. Number three,
Oh, I didn't even think about
Yeah,
that. You can give away the deed and not even have the
and not even get
the
your
money exchange.
promise to get the money in a few weeks or over a promissory note without properly securing that promissory note. No lien. You can give a lien, a mortgage, but you're in second or third position. So if they stop paying you, you're out of luck. Buyers can buy properties with existing violations on them, existing assessments, condominiums, for example. You get in there and all of a sudden you're responsible for fixing the balcony on your unit or the roof share. So you want to order what's called an estoppel and see that there's nothing outstanding and nothing pending.
Okay. And you should do that before.
We always do
The
that
sale.
before. Yeah. It's part of a due diligence of the buyer.
I can see that a lot in condos,
Mhm.
especially down here. Yeah, no, you can see there's assessments that condo owners may not know, buyers may not know about when they're going into it, and then they buy the condo, and all of a sudden they get hit with this huge assessment.
Another common area or unexpected occurrence for buyers is, a seller might own a home for 30 years, and by virtue of the Save Our Homes cap and the homestead tax break, they're paying very little tax. Well, when you come in as a buyer 30 years later and buy that property, taxes are going to be assessed on what you paid for it. So you might think your taxes are really low, but the year you get into it, your taxes are going to take a significant jump.
Yeah, so I guess if you're looking at, what did the owners pay taxes for last year, it'd be totally different than what you're paying for.
You need
the
to do
following
your
year.
due diligence and find out what am I going to be paying here.
Okay.
Factor that in.
And the attorney can do all that for the buyer.
Yes.
Okay. When should let's say a buyer, when should a buyer first consult with an attorney if they're interested in buying a residential property?
I always tell people, have your lawyer look at the contract. So before you sign
anything,
before you sign that purchase contract, have a lawyer eyeball it. We have something called the Florida FAR Bar here. It's a great form. It stands for Florida Association of Realtors and the Florida Bar. They came together and made a standard form. So there's generally if you use that form, FAR Bar, is no surprises, provided that it's filled out properly.
Okay.
You still got to fill in the blanks properly.
And both sides fill in the blanks?
So typically, yeah, if there's realtors involved, they usually generate a draft, but don't sign it until your lawyer looks at it. There's a rider under the FAR Bar where you can sign it subject to your approval of your attorney. In other words, so let's say you really want to tie up a property and you don't want to play games and lose it. You can sign the contract as long as you have that subject to lawyer approval rider,
Okay.
which will give you 5 days for your lawyer to bless it. That's a really neat tool.
That's a great tool. That's a great tool.
Yeah.
So listeners, you're listening to Tony Damianakis. He is an attorney here, a special guest on FLALAW on the radio. We're talking about real estate law right now. We will be talking about probate and even commercial and business law. So if you have a question, this is the time to give us a call, 727-441-3000, or jump onto our Facebook Live page at Pernick, Caulfield, Averill, and Noyes Injury Lawyers. And you can type in your question there, or jump on our YouTube channel and you can see us and send us a question through our YouTube channel as well. I'm Matthew Noyes. I'm one of the attorneys at Pernick, Caulfield, Averill, and Noyes, the presenters of FLALAW on the radio. And I can answer questions or address comments regarding personal injury matters, workers' compensation, and Social Security disability matters. So this is the time to capitalize on two attorneys giving free advice to you and answering your questions for you. So I encourage you to do that. If you can't and you still have questions and you want to listen to the show later, after the show, we do upload our episodes to your favorite podcast platform, including Spotify, Apple Podcasts, and others. So you can find us on FLA Law on the radio on your favorite podcast as well. But Tony, I wanted to get now, because you have all kinds of experience in other areas of law, I suspect that your experience in those other areas help you in the real estate practice as well. Can you tell our listeners a little bit how your experience in the other areas of law help you in the real estate?
It really is a blessing to be able to do different areas of law, because it's hard to find lawyers with experience in each area. I'll give you an example. Right. You do probate. Grandma leaves someone a property, but the deed, someone tried to do a quitclaim deed or messed up the chain of title along the way. If you just did probate and you go through the probate process and you would get the property at the conclusion of the probate, no one would be able to tell you that there's title issues before then.
Oh, okay.
So I can pull up a deed. I can identify issues right away. I can go back in the chain of title and say, oh, Grandma thought she owned this property and she thought she was leaving it to you. But when Grandma took this property through a quitclaim or whatever it is they did, she forgot to have her ex-husband or her then husband sign it. And because it was homestead, that quitclaim was ineffective, and you've got a problem here.
Oh my goodness!
And so we'd be able to help people. That happens a lot.
Does it really?
Yeah.
I guess it would happen a lot here in Florida, especially.
Homestead in Florida is a very unique situation under the law. Spouses have to join in if you do anything with a homestead. If you're going to know no other rule regarding homestead, when you try to convey it, spouse has to join in.
Okay.
And if they don't, it's ineffective.
Okay.
And that could create a whole chain. For example, we see a lot of mixed marriages. So husband and wife have come into a marriage from previous marriages, and they have properties from previous marriages. And the understanding is, okay, whatever I had coming in is going to go to my kids. You leave your things to your kids. And whatever we do together, we'll just split among all the kids. A very simple plan,
right?
Unless there's title issues, right? So there's what we'll call cross-referencing between real estate, probate, and other areas of expertise really comes in handy.
Right, and I think what else comes in handy, especially with probate, is your experience in the business law and the commercial law. Can you tell our listeners a little bit about how you work in business law?
So the way I got involved in business law is when I moved to Florida, my initial job was in-house counsel for a developer.
Okay.
And he had several LLCs and corporations, real estate development, hotel development. And that's where my exposure to corporations, corporate law, and being inside a business as general counsel. So it's one thing to have a firm like we do and have the folks come to you. It's one thing to be in-house counsel in a business, and anyone can walk in your door at any time and say, I need this, I need that. So I have a sense of what a business perspective is. I try to bring that to my practice and to my business clients. They don't need a big legal memorandum. They don't need a fancy lawyer. They need an answer.
Right.
Can we sell this? How do we sell this? How do I buy out this partner? What happens if my partner dies? They need answers, and they need them quick. So that corporate experience began with my in-house counsel experience. So today what I do is I serve corporations. We form corporations. We help folks with the corporate minutes, shareholder agreements, mergers on a small scale. And naturally when they
buy. You wear so many hats. Yeah. That's wonderful to see, though, but that's wonderful. So you help organize and create businesses.
For sure.
Yeah. What do you see as the biggest mistake people do when they're trying to start up a business or to grow a business in Florida?
The biggest mistake you can make as a business owner is commingling funds. So you form there's a concept of pierce the corporate veil. Our society created this legal concept of a corporation so that people would be able to take risks and be shielded from personal responsibility. So if you, Matt, wanted to start a pizza place and you called it Matt's Pizza Inc., you went on the beach, you rented this expensive place, didn't work out like you thought, you ended up not being successful as a corporation. If you operated it properly and did not commingle funds, they can't go after you personally. So you'll be able to regroup and start another business. That's part of what made America great. This atmosphere where businesses could take risks and hopefully flourish.
Right.
Commingling funds means you didn't operate like a proper corporation. You took corporate money and you put it in your own account directly. You were using it for your own benefit, not for the benefit of the corporation. You can pay yourself as much as you want as a corporate owner, but you have to go through the corporate account. You have to do things right. You have to keep minutes. I'll give you a brief overview of corporate structure. Okay. Every company is owned by shareholders. Typically, if you form a company, Matt's Pizza has got one shareholder, 100% of the shares. IBM has thousands and thousands of shareholders. They went public, but they're still owned by the shareholders.
Okay.
Shareholders by law, have to have a meeting once a year at least, and they appoint directors. Directors will make policy. In Matt's Pizza, you're the shareholder, you're the director, and directors appoint officers. President, vice president, secretary, treasurer. Guess who Matt's Pizza's
I get to do all of them.
You're it. But that's still a legitimate corporation.
Okay.
You have to create those minutes. One-man shop, you still need those minutes.
Okay.
You keep them private. They're private. You keep them in your corporate book. And you're walking, talking, and acting like a corporation. Open up a corporate account. Do all your business in that account. Pay yourself as much as you like.
Out of that account.
Out of that account.
But the accounting has to be accurate.
Yeah. So don't commingle funds. Take the time to do the minutes. Get the legal advice you need to make sure you have the corporate structure down. And have a good accountant.
I think that's so important.
You need to keep good books.
Yeah, I can imagine that's so important. And I suspect that partners or shareholders of the smaller business come to you and say, "Hey, my partner and I aren't getting along." Well, how do you deal with it? And more importantly, how do you prevent partners in a corporation from disputing in the future? What can you do as an attorney to reduce the fighting that you sometimes see in corporations that oftentimes result in the dissolution of the corporation?
Yeah, great question. You can't make people not fight, right? But you can tell them what their interests are, and often it's in their self-interest to keep it together. I'll give you an example. I had a case where a common scenario is 50-50 partners just can't get along. They don't make decisions, and what you have at 50-50 is what's called deadlock, stalemate. If you can't come up with a way to move the ball forward, you have to dissolve the corporation. Dissolution is the worst possible outcome for any corporation because you basically sell things on the courthouse steps.
For
the bottom feeders will come around at auction, buy
garage sale prices,
and nobody wins.
Yeah.
Right. The alternative to dissolution is to sell the business for fair market value, and then they'll have to split and settle their disputes, perhaps in court or out of court. So we try to create shareholder agreements wherever possible, which foreshadow and look ahead in the event of a deadlock, giving one partner or the other the right to buy the other out at a certain price. It could be fair market value, it could be an appraised value. There's something called the Chinese option, where if you make an offer and say, okay, I'll give you $100 for your shares, and I don't do it, then I can buy you out for $100. So
I
it
see.
doesn't pay for me.
If it was good enough for
Right.
you to offer me, then it should be good enough for you to accept it.
Yeah. So that prevents gamesmanship
Yeah.
and games, right? If you make an offer, it better be a serious one.
So do you think that there should be an odd number of decision makers, or somebody have 51% instead of 49%, or
51 is often preferred. You obviously, if there's only two partners, you can't have an odd. You have to. That's the
Right.
people who've invested. That's the people who are working. 51% certainly makes it clear there won't be deadlock.
it's hard to agree upon that?
But
though.
if it's not fair, it's not fair.
Right. What red flags do you see, like in business contracts, that often lead to litigation?
So when a business sells, it can be done one of two ways. Typically, it's done with asset sale, or it can be a stock purchase.
Okay.
Most of the time, a buyer wants just the assets. He doesn't want to buy the stock because he doesn't want to buy any headaches that the business may have had. Where I see things go awry in an asset purchase is where not all the money's paid at the table, and the seller keeps what's called a seller finance note.
Okay.
In there,
It
invariably,
sounds like it's going to be bad.
the buyer gets in there, everything's great for 6 months or a year. All of a sudden, the buyer gets squirrely. Things are not what they wanted, or the buyer has a drug problem or an alcohol problem, and they stop paying your note. Then you got to go back as the seller, who's hopefully your closing was done by an attorney that gave you a security agreement, promissory note, and ways to enforce your debt.
Right.
You go back and you, at best, can take back the business. And the question becomes, what are you going to find?
Right.
Did this buyer run it into the ground? Did he destroy the equipment and the materials? Did he destroy the reputation of the business? Are there any customers left?
Right.
That's where it's risky. A lot of times sellers fall for what they get is a higher purchase price, and it really looks good up front. But the risk of getting all their money on the long term is high.
Right.
So I encourage people, depending on the circumstances, there's been deals where they're great
Right.
if you're properly secured, and there's been deals where it's just nothing but headaches. If you can get your money at the table, get it at the table.
I can imagine, because it always looks great. The seller can be, or the buyer can be all excited. He's going to open up a new pizza place. He just can't wait to get it going. And then if the seller is the one who holds the note and business slows down, pizza doesn't taste as good as it did when the seller made it, the buyer can say, well, I'm stepping away. And then the buyer is stuck, and he has to either go back into the business or litigate. I guess he would have to litigate against the buyer.
Yeah, litigation is an expensive endeavor.
It is.
And I try to discourage it, even though it's a significant part of my practice. I discourage it, and I look for solutions right up front. I always talk settlement with the other side.
And you also, when you're planning, when you're creating the business, you think about the possibility of litigation. And so I assume in your agreements, you take all that into consideration.
Yeah.
You can always say, oh, these guys are best friends. They're never going to fight. This business is going to be wonderful. But lo and behold, there's going to be fighting.
Yeah.
And so it's always better to be careful and to address those possibilities at the beginning, as opposed to after the fire has started, so to speak.
And that's another example of the cross experience benefiting.
Right, because you've done
you can
litigation, you know what
anticipate
happens.
The problem areas, and you stick it in the agreement.
Yeah. Now, have you seen a lot of businesses refer to or turn to, I call them Google Esquire, and pull up online forms and try to create corporations or agreements using the online forms that they're able to pull up? I guess AI is a new monster all in itself, creating forms for you. What's the risk with that, and is there really danger to relying on Google Esquire?
Google searches, Google Forms, even legal websites like LegalZoom and other types of things like that have a very limited function. They're good to give you an idea of what to expect, but they're not going to explain to you how to use that form. You know,
Right.
even LegalZoom, if you can go there and form a company, but what good is, someone handing you the keys to a plane if you don't know how to fly it?
Sure.
That's the lawyer's role. Okay, I form you can go, anyone can go to the state of Florida and actually work their way through and form the company. But if you don't know how to use it, you don't know how to drive that car, you're going to take the wrong road and you're going to have a problem. So I would caution people, there's nothing wrong with, the internet in terms of exploring it, but
Getting guidance.
don't think
Yeah.
that you should live without proper legal advice in a business, in a purchase. There's a reason why lawyers are important and protect investments, livelihoods. They truly do serve a good function.
And especially if you do it in the beginning, so you don't
Right.
have to worry about it into the future, or you protect yourself. You have an avenue to reduce litigation if you can. So that's so important. Can you share with our listeners, without naming any names, but a case that you handled that taught you the important lessons about litigation strategy and business creation and such like that? Stump you. See, you came back from vacation and I stumped you.
So you're always surprised in litigation. Sometimes you think a case needs to be settled, and you see the two sides are stubborn, they have resources, and they keep fighting. I've seen clients fight over a $50,000 bill and end up paying $250,000 in legal fees.
Yeah,
It doesn't sound real, but it's real.
I can imagine.
Right?
Yeah.
So it's really hard for people when they get into these situations to take and make smart business decisions and not emotional decisions or decisions based on pride. That's what, if your ego gets in the way, you're going to make some bad decisions.
Right. You're going to pay the price for it.
And so as a lawyer, I find myself sometimes arguing with my client against proceeding in litigation, trying to warn them that you're not going to be happy at the end of this road. You're not going to get the result. Even if you win, it's ironic that you win $50,000 and you had to spend $250,000, right?
I have that same discussion with my clients sometimes when they want to, if we're in litigation and there's an offer to settle the case, and the client says, just for principle, I want to take it further and further. Well, I can tell them what their net recovery would be after attorney's fees, cost, and medical bills. And then I can tell them what a jury would have to award for them to net the same amount. And it's far higher because of the cost of litigation, the increase in attorney's fees and such. And I think it's important that our role as an attorney is to let them know that, here's the risk you're taking. I always say, it's your boat. I'm the captain of the boat. I'll let you know if you're guiding us into rocks. But if you want to guide us into rocks, I'm going to scream and shout about it. But if you guide me into rocks, it's your boat that's going to get damaged. But I think it's important as the attorney to really have those conversations with your client, to be, as I said, to be the advocate, to let them know that your heart may be telling you something, but your head should be telling you something else. And so I think that's a role that I know that you do in not just your real estate, but also your commercial and business, and even probate. You have to do that role. And I think that's so important. And that's what makes a good attorney, I think.
We've been fortunate. That's why we don't advertise. We just work off of word of mouth. People will leave generally with a good taste in their mouth, and they'll say, yeah, call this guy.
Yeah.
And that's how we roll.
That's wonderful. Yeah.
Thank God it's been working.
Yeah. I've had several of my friends, use your services, and they always say great things about you. And I said, oh, I already know that. Tony's a great guy, so keep it up. And so we do have about 15 more minutes left on FLA Law on the radio. Again, this is live right now from 5 until 6 on Tuesday. So if you have a question for Tony or myself, give us a call at 727-441-3000 or jump on the firm's Facebook page. We are Facebook Live right now at Perronick, Caulfield, Averill, and Noyes Injury Lawyers. We are also live right now on our YouTube channel. So check us out. Send us a question. We'll be happy to address your questions, your comments, or your concern. Tony, we've been talking about your area, your practice areas of real estate law and commercial and business law, but you also do a lot of estate planning and probate. So while we have a few more minutes, let's talk about that if we can. And I'm going to ask you the same question I asked you for the other areas of law. What's the number one question that your estate planning clients ask you when they first come to meet with you?
Folks come to me wanting to understand the difference of a will. How does a will work? What is the difference between a will and a trust? How does a trust work? How does a durable power of attorney work? What are the costs involved with these things? How do you prepare them? How much does it cost to prepare them? And what is the back end? What happens when you die? How do you protect assets? Estate planning is a really important tool. You'd be surprised what can go wrong. And
without proper planning.
Yeah, without proper planning. And even sometimes you have a plan. And what I see sometimes now with elderly clients who've become widowed and subsequently become vulnerable, either with dementia or just old age and health, they'll remarry. And guess what? That second or new wife has a whole bunch of rights that none of the kids thought would be a problem.
Okay.
Because they had, they had a good estate plan.
Right.
So you need to be mindful of your circumstances. If you have elderly parents, you need to know what they've done. Sometimes that's an awkward conversation, going up to mom or dad and say, Mom or Dad, do you have an estate plan?
Yeah.
And they might look at you, oh, you're just worried about getting my money or whatever. But no, you just want to make sure you have everything in order. If people don't have a will or a trust, the state of Florida will give you one. It's called intestate.
Okay. And a lot of people think that means that the state of Florida gets all your assets. That's not the case.
Yeah. In many circumstances, intestate is not so big a deal. For example, in a simple scenario, husband and wife, 3 kids. The husband dies, the wife has control over everything. The wife dies, the kids will get everything, even without a will. There will be the need to probate it, and there'll be some costs there.
Sure.
But it's still going to be okay. Where intestate is not good is if you didn't want, one kid to get something, or you want one kid to get more than the other 2. Any variation of equal shares has to be written, has to be directed in the form of a will or a trust.
And in today's world of all this complexity, is a simple will enough, or should everybody have a trust?
No, it depends.
Okay.
We actually do things. We have techniques of avoiding the need for a will or a trust.
Okay.
In certain samples.
Yeah, why don't you tell our listeners about that?
So if you just, for example, have a house and you want to you have a house and a couple of bank accounts, checking and the savings. There's something you can do called an enhanced life estate deed, otherwise known as a ladybird deed.
Okay.
Where you can put the house give yourself a life estate, which means as long as you're alive, you can stay there. You can even sell it if you decide to sell it. But when you die, it'll go directly to whoever you name. So that works like a will, but there's no probate involved.
Okay.
And so it's called an enhanced life estate deed. So you take care of the house with that deed.
And does it have to be a family member, or it could be anybody?
It could be
that you leave it
anybody.
to?
Yeah.
Oh, very good.
The only thing you can't do is you can't leave a spouse out. Right?
Okay.
So husband and wives have rights. Assuming that's not what we're talking
Right.
about. You can leave it to anybody.
So you can keep the house out of being probate.
Right.
Okay.
And then you can go down to the bank and arrange for survivorship status on your bank account.
Okay.
POD, pay on death, or survivorship accounts. Depending on the bank, they have different terms, but it's the same concept. Upon your death, that account will automatically, by operation of law, belong to the person you name. So in that simple scenario, with an enhanced life estate deed and survivorship accounts at the bank, you're done.
You're done.
No probate. You don't hear much about that approach because lawyers like to do wills and lawyers like to do trusts, and there's more
Right.
fees involved. But that's the kind of service we provide. We're saying, hey, an enhanced life estate deed costs you $600 and you're done.
Okay.
There's
Yeah.
no probate. There's no nothing to worry about in the back end.
And in other, like, let's say, brokerages accounts and such like that, or life insurance, can you avoid probate by properly designating a beneficiary?
Great question. Life insurance, yes, you always should designate a beneficiary, and that's outside of probate. All the beneficiaries have to do is present the death certificate, and the insurance company will cut them a check. Stock accounts, you could also name it your brokerage accounts survivors or beneficiaries. You have to be careful to do that. And
Why's that?
Because sometimes brokers will mess up, or sometimes the account might be complicated. Certain stocks may have beneficiaries'
okay.
names, certain
Right.
stocks may not, depending on how they evolved in your portfolio. So you want to work closely with your broker to make sure that was done. Annuities will go automatically. IRAs will go automatically. As long as you name a beneficiary, it'll go there.
Now, I used to teach probate a long time ago over at St. Pete College, and I remember there was at least a case or two where the decedent had life insurance, but the beneficiary was to his estate. How wrong is to name your estate as the beneficiary?
So that's just defeating the purpose. That's going
Exactly.
to have to be probated. So it'll go to your estate. Whether you have a will, it'll go pursuant to your will. If you don't have a will, it'll go intestate, equal shares to your survivors.
And there's attorney's fees and there's personal representative fees possibly on all those assets as well.
So great point. We didn't discuss the cost of probate, and the importance of avoiding it is to avoid those costs. Typically, an attorney fee in a probate setting will be 3% of the value of the estate.
Okay.
So depending on how big the estate is, that's how big the fee is.
Right.
And then the personal representative is also entitled to a fee, also up to 3%.
Okay.
So there are fees there that come out of your beneficiaries' pockets.
Yeah. So if you have life insurance and let's say it's $100,000, 6% of it could be gone just like that.
Yeah, big mistake.
Yeah. Yeah. And also we talked about pay on death accounts, bank accounts and such like that. I've heard people say, well, I don't really want to put Johnny on my bank account because I don't want him to take all the money. There's a difference between a joint account and a pay on death account.
Huge difference.
Okay. Can you tell our listeners about that?
Pay on death means they only have access and control and ownership upon your death. Joint account, they can walk into the account with or without your blessing any day of the week and clean it out.
Okay.
That's the difference.
And that's a risk that we take when we're talking about durable power of attorneys too, right?
Yes.
Can you talk a little bit about that? Because, we always hear people say, well, you have to have a durable power of attorney. It's so important to have a durable power of attorney. What's the risks with a unchecked durable power of attorney?
So when we prepare a durable power of attorney for clients, we always make them sign a letter acknowledging how powerful that document is. Whatever you can do with a pen, your agent can do with a pen in your name.
That's scary.
So you better give it to someone who you trust 100% without reservation. The reason why we do these things is, God forbid you had a stroke or become incapacitated, they'll be able to go down to the bank and do things in your name so that the house is protected. Your assets are protected. If you give it to someone you trust, it's a good idea.
Right.
Do not give it to anyone you don't trust.
Right. And you can revoke the power of attorney
Absolutely.
anytime as well. So
Absolutely.
if something happens that trust is questioned, it's important to revoke the power of attorney.
Yeah.
But there's so many ways that you can really avoid probate. And formation of a trust is one of them. I know we only have a few more minutes on today's show. That means I have to get you back on another show. But can you tell our listeners, the difference between a trust and how does that avoid probate?
So the trust is a great tool. Think of it as a box. You create this box, and then you put your assets in it. Your house, your bank accounts, your brokerage accounts, whatever you choose to put in there. And then the trust comes with a set of instructions that you set up. So you say, during my life, I'm the trustee, which means I'm in charge of the box. When I die, there's going to be a successor trustee named. And then you tell that successor trustee what
These are the instructions.
are. Yeah.
That's a great analogy. I like that. I never heard of it that way. That's
When
wonderful.
I die, I want A, B, and C to get these these assets. That does not need probate. That is private. That does not need court approval. And it's a great way to avoid probate.
Yeah, it prevents the public from seeing what your assets
Yeah.
are as well. So I think
Yeah.
that's so important.
There's two types. One is a revocable trust. One is an irrevocable trust. They each have their own setting and reasons. But if you ever hear of inter vivos or revocable trust, it's a very strong tool. It's more expensive than a will, so it's more complicated to set up, but it saves you thousands of dollars on the back end.
Without probate. That's very good. Tony, thank you very much. I appreciate you spending an hour with me, especially the day after your vacation.
It went quick.
It did go quick. Why don't you, before we wrap up, though, why don't you let our listeners know how they can get in touch with you?
We're at Peacock, Gaffney, and Damianakis on Sunset Point Road in Clearwater.
Right around the corner from us.
Right around the corner. And our phone number is 727-796-7774. Just ask for Tony.
And your your website?
Website's Peacock Gaffney, PeacockGaffney.com.
Yeah, and listeners, if you can't write that down, if you can't remember that, you can always reach out to us as well over at Parent Caulfield, Averill, Noyes. We have attorneys that we really recommend and refer to in areas of law that we don't have, and I can tell you that Tony is the attorney I refer to, and actually his partner as well, Patrick, for the Family Law Matters. These guys are great guys, and they take time and they really care about their clients. And so thank you, Tony, for being an example to other lawyers as well.
Thank you, Matt.
All right. Well, listeners, thank you again. If you want to re-listen to this episode, or if you want to listen to past episodes of FLA Law on the radio, we are on Spotify, and we are on Apple Podcasts, and we are on your favorite podcast channel. So just look up FLA Law on the radio, and you'll be sure to find our episodes, subscribe to us, follow us. But in the meantime, I always encourage you to drive safely and watch out for those who don't. Take care, and I'll talk to you next week. Good night.